Okay, just a couple more minutes as people are joining. We'll get started. NABOR versus FRBAR is one of my favorite classes, so uh, should be good. And you should always ask questions. If you have a question or something comes up or you don't understand, y'all should feel free anytime to just you can either put it in the chat or you can just unmute yourself. And I'm happy to take questions throughout the presentation. I think it makes it for a more interactive and learning experience. Okay. All right, everybody, it's 10 a.m. Let's get started. Today, we're going to be talking about the NABOR versus the FRBAR contracts, kind of a which one should I choose, go through the forms and talk about the differences and whatnot. As I was saying a few minutes ago, I really like this class because I think it's important that you understand the tools in your tool chest, and that's really what the contracts are. So of course, I'm a lawyer, and lawyers have disclaimers. So we start off with a disclaimer. Just know that I'm not giving you specific legal advice. If you have any questions, you can call me or text me anytime. And I will also say this: you can put your questions in the chat or just unmute yourself at any time and just say hello and ask your question. I don't mind being interrupted. I think it makes for a more interactive and exciting presentation for everyone to learn together. So with that, let's get going. A little bit about me, just so you know who I am and who's speaking to you. I'm in my 20th year almost as an attorney. As a matter of fact, my anniversary is in about 2 weeks for 20 years as a lawyer. And I focus on real estate and business transactions. I think it's important for this class in particular that you know I'm the chair of the Legal Resources Committee at NABOR. That's the committee that drafts the contracts. And then I also serve on the reptile section of the BAR's REAL committee, which is the Residential Real Estate Industry Liaison Committee. And then a subcommittee of that drafts the FRBAR contracts. So I have offices throughout Southwest Florida, but we close across the state, from the Panhandle to Miami to the Keys, and we really enjoy what we do in my office. So if you have any questions about closings, just give me a call. Today, we're going to compare the FRBAR contract to the NABOR contract. We're going to discuss the pros and cons. I'm going to use the main contracts as my comparison tool. I know the FRBAR as is, of course, is the most popular contract, but everything pertains the same, except, of course, for the inspection sections. So we will compare the differences, and I'll point out similarities as we go. Before I dive right into the forms, I do want to point out a couple of things. First of all, you know, the contract is your tool. A carpenter uses a hammer, a lawyer goes to court, a realtor uses a contract as their tool. And both contracts have many positive attributes. Both have some areas of concern. And really, when I get asked the question a lot, should I use this contract all the time? Should I use that contract for other things? And the real answer is it depends. Who's your customer? What's the status of the deal? if it should be as is, the location of the property, the financing status of the parties. It just depends on what your customer's situation is. So that's really what we're going to talk about today, is when to use which contract. Apologize, excuse me. So we're going to start right at the top of the contract and walk through the forms. I'll be, again, pointing them out, the differences. And right off the bat, on page 1 of the contract, you have to talk about the property that you are selling. Of course, you'll put the names of the parties on the top of the forms, the buyer and the seller. And then you have to describe the property that you're selling. And both contracts have blanks for that. Some of the important differences: FRBAR, the washer and dryer, does not convey, whereas NABOR, it does. So if you want to convey the washer and dryer and you prefer the FRBAR form, or you're using the FRBAR form, make sure you write in washer and dryer on the blanks that allow for inclusions. FRBAR talks about built-in appliances and built-in furnishings with the real property, whereas NABOR actually has a list, a comprehensive list that defines all of the property. And that includes things like the pool equipment and other more specific items. So you'll want to read those 2 paragraphs and understand. NABOR includes landscaping specifically. Both contracts have been updated to include smart home features. So that iPad that controls the fireplace, and the lighting, and the pool. If it's not the personal iPad of the individual, but the iPad for the home, I would argue that it stays. One major difference: you put the property identification number on the FRBAR contracts, and not on the NABOR contracts. But the NABOR contracts have a space right on page 1 for the amenities of the association. So if you've got a parking space, a garage, a cabana, you would put that right on page 1 of the NABOR contract, whereas FRBAR, if you're conveying in a homeowners association or a condominium, you would use the correct association rider and put the amenities list there. One thing that I will say about FRBAR: while landscaping is specifically included in NABOR, landscaping has to be maintained under FRBAR. So don't forget that. It's not like they can just take that favorite tree in the front yard with them. It's very clear under the FRBAR contract that if it's screwed or glued, it stays. That's the built-ins. The thing about NABOR is the list is rather exclusive. So if it's not listed on the NABOR contract, that means it does not convey. So if you have things that are going to convey that are not screwed or glued, you need to make sure you write them in on page 1 of the NABOR contract. Okay. Up next, the next section, of course, is the offer and acceptance and the closing date sections of the contract. This is kind of a big deal, especially on the as-is forms when you're calculating dates, because the effective date of the FRBAR contract is the last date the contract is both signed and delivered. The NABOR contract says the last date set forth on the contract by either party. So what does that mean? Well, FRBAR, you don't just sign the contract, you have to get it back to the other side, whether it's an offer or a counter offer, for it to be effective. NABOR becomes effective when everybody has signed it, but you still have to deliver the contract back to the other side. It's just that the effective date may not be the delivery date. With FRBAR, the effective date is the delivery date. As an example, I like to give, it's 10 o'clock at night, you finish negotiations, the contract has been sent around for signatures, everybody is signed on today, but you are tired and you've gone to bed and you don't deliver the contract until tomorrow morning. Well, under NABOR, the effective date is today, so the first day of the inspection periods is tomorrow. Under FRBAR, the delivery date being tomorrow, that's the effective date. So the first day of the inspection period would be the next day. So when you're counting your days, it becomes very important to know the effective date and when the contract was actually delivered. Another thing about the closing is that FRBAR defines the closing as when all funds and documents are received by the closing agent at the time decided by the closing agent. NABOR does not define closing. It just says that it occurs on the closing date in the county where the property is located. So there's a little difference there as to when things are supposed to close, but generally under both contracts, they close on the closing date. And as I'll talk about later, time is of the essence under every deadline in FRBAR, but for NABOR, it's only the closing date. So we will have a closing on the closing date stated in the contract under both deals. And of course, the Consumer Financial Protection Bureau, those are extensions that can be provided for lender compliance. FRBAR used to be 10 days. It's now only 7 days, whereas NABOR is still at 10 days for an extension if needed for CFPB, Consumer Financial Protection Bureau compliance. And of course, that's your closing disclosure delivery, which the buyer has 3 days to review the CD to make sure they want to go through with the deal, even though they do not have a right to terminate.
Hey, Sam.
We have some questions about delivery. Can delivery be by email? Absolutely. This contract, both contracts say that delivery by email counts. What they do not say, or what they also say, is that texting does not count. No more texting in the contracts. I know that's frustrating for some of us that love text messages, but you have to email the document to the other party for it to be effective. And it's calendar days. I see a question about business or calendar days. All the contracts use calendar days for everything. It's not business days except for delivery of association documents for condominiums. That's a 3 business days to terminate after receipt of the condo docs, or in a homeowners association, receipt of the homeowner association disclosure. Everything else is calendar days. So the next big difference in the contracts is the assignability. I think this is very important because a lot of people like to use the FRBAR contract for fix and flips, or assignment contracts, or A to B, C contracts, they're called. Under FRBAR, you have to check the correct box for assignability, because the default under FRBAR is that a contract is not assignable. Whereas under NABOR, they are freely assignable up to 15 days before closing. So if you want to assign your contract, if you want to transfer the property into a trust or an LLC for your buyer, you got to follow the assignment deadlines. Under FRBAR, you would check the appropriate box in the assignment section for assigning and releasing, assigning and not releasing, or no assignment. Under FRBAR, if you did do an assignment, you would have an attorney prepare the formal assignment form. Under NABOR, they provide the additional assignment form to notify the seller of the assignment. Interestingly, under the NABOR form, you don't need seller's signature because it is in fact freely assignable up to 15 days prior to closing. If you did assign within 15 days of closing under NABOR, then you would want a formal assignment prepared by an attorney. Okay, before I move on, does anybody have any questions on the stuff we've covered so far? Yes, Kat. Did you have a question, Kat? Yes, it applies to sellers too. And I see the question is, you can always use my slides and keep them and use them. I see a question about that as well.
Can we print them?
Okay. Up next, let's talk about methods of payment.
Sam?
Yes, ma'am. Yes, Christina.
Thank you. Hi, Christina. Could you give a good example? I mean, I'm assuming it's just because it could slow down the contract, but could you give a good example as to why the assignability on the FRBAR could be a hindrance to those selling a home?
Well, if you're doing assignments, the question about assignments is, The seller has spoken to the buyer. They've reached an agreement. They've signed a contract. And maybe the seller wants to deal with this particular buyer. And if the buyer assigns the contract to another buyer, now the seller doesn't know, are they creditworthy? Have they provided a proof of funds? There's a lot of reasons to not want a contract assigned. Let's see. Putting a house in a trust, Chet, that would be an assignment. A trust is a separate legal entity, and you would want to do an assignment into trust. It's not as big a deal, of course, if the trustee is the buyer, but especially if there's a different trustee, a corporate trustee, a third-party trustee, you would want to do an assignment to clarify that this particular buyer is now out of the deal. Okay, moving right along.
Sam, before you move in, I'm so sorry. Can
yes,
I ask
Kat.
you a question? I have a neighbor as it is contract right now. Seller is being changed a last minute. Closing is about to be a week for now. On the contract, it says that it was going to be assigned. Do I need to submit an addendum changing the sellers if and the other side is an FHA loan?
The seller is changing. That's very interesting because the sellers normally cannot assign contracts. Was the incorrect seller on the contract from the beginning?
It was the owner of the lot, and this is a brand new construction home. So investors are the ones that are going to be the sellers.
So you actually wouldn't assign the contract from the seller. That would actually be a separate transaction between the seller and the developer, and then the developer to your buyer. That's an A to B, B to C contract. So that's not necessarily an assignment. That's a flip.
Oh, it's a flip. Okay. So do I have to submit an addendum?
You probably would need to do some type of paperwork, either a new contract between your buyer and the developer, and then the developer and the seller.
Okay.
Give me a call afterwards.
I'll call you after the training.
That's a little different than an assignment.
I know. Thanks.
Okay, so methods of payment. Obviously, there's going to be a funds transfer for a sales transaction. FRBAR has changed the contract in the last few years. Now, if you check the cash box, there is no financing contemplated, and it just says this is a cash transaction without a financing contingency. I see an error in my slide. It says without financing contingency. So, and then there is no CFPB window to comply, and you must hit the closing date. There is no CFPB extension on a cash deal. And that's also the same under NABOR, but the NABOR contract contemplates that a cash contract may still be financed. There's just no contingency for the financing. So if the buyer doesn't get their financing, they can't get out of the deal. The buyer will pay cash, but may obtain a loan, is how NABOR phrases it. So you've got a little bit of a difference there. Again, there is no compliance window for CFPB, which means if the lender doesn't get the CD to the buyer and the buyer's got to wait 3 days, you need an extension. Again, you must hit the closing date under both contracts. Now, financing, we're talking about some major differences between the contracts. I get a lot of questions on financing between the two, and there seems to be a lot of confusion under NABOR about what their financing contingency says. So let me just kind of go through them both. Under FRBAR, its default is a 30-day loan approval period, and the lender has got to get the appraisal done. There's got to be a diligent effort is defined. It's got to be completed by the buyer. You got to pay for that appraisal, give the lender their fee, get the documents to the lender. And you have to terminate the FRBAR contract in writing prior to the end of the loan period, or the buyer's going to lose their deposit. If you can't close, the buyer loses their deposit under FRBAR. NABOR is different. NABOR's got a 45-day default, and the buyer and seller may terminate if no financing is approved at the end of the 45 days. So they're very opposite. FRBAR, the buyer loses the right to terminate at the end of the loan approval period. NABOR, buyer and seller gain the right to terminate at the end of the financing contingency. But the buyer under NABOR must provide an adverse credit action letter or proof of good faith to try and get the loan with no approval or denial at the end of the 45 days. And then, of course, under NABOR, the buyer must affirmatively waive the contingency in writing, or the seller, I wrote seller keeps the deposit. I'm sorry, that's a mistake. That's wrong. Don't copy that. I'll fix that before I send it out. But the seller can terminate. If the buyer gets approved under NABOR and doesn't terminate, then the seller probably can keep the deposit if they don't go to closing. So be very careful there. NABOR gets a little tricky because the parties have the right, gain the right to terminate. Now, I will tell you, I want to warn everybody about a court case. It's called Florida Finance Investment Group 100 LLC versus LaFont. When you're filling out your finance contingency, and I personally, although this has not been proven in court yet, but as I read this case, just as some attorney, this applies to both the FRBAR and the NABOR contract, but it was a FRBAR contract that was determined to really screw up a buyer. They lost a big deposit because they did not apply for the loan stated in the contract. So when you fill out the FRBAR or NABOR financing contingency, you check the box for the type of loan, you enter the interest rate, the amortization period, you put all your information for the loan in the contract. If your buyer does not apply for that loan, you need to do a contract amendment. So if anybody has any questions about that, let me know. We have a couple of questions in the chat. Cash contingency, if the buyer is even thinking of getting financing, the NABOR contract will be better. I would say that's probably correct, Maria. If the buyer is getting financing, but they're not 100% certain as to what kind of financing, especially given the LaFont case, I would use the NABOR. Tammy, is that?
Sam, I have a question. Are you, just so I understand, do you mean if a contract says somebody's going for a conventional loan and they decide to go for an FHA, that would be a breach?
It's not necessarily a breach. It needs to be an amendment of contract, though, according to this case. That's exactly what I'm saying. I don't know that I would call it a breach of contract, but if you switch from conventional to FHA or conventional to VA or switch any of the loan types, I would do an amendment to contract given what this case says. Yes.
Thank you.
Tammy is asking if the buyer wants to change the financing type, can they do so? They need an addendum. It's an amendment, Tammy, but I would do an amendment to protect the deposit. Exactly. Kathleen, can you review again regarding terminating with or without a mortgage commitment? So Kathleen, yes. So you want to terminate under FRBAR within the loan approval period, and you do that in writing. Under NABOR, you have to terminate after the end of the loan approval period. And NABOR doesn't call it a loan approval period. They call it a financing contingency, but you would terminate at the end of that, whereas FRBAR, you do it before the end, and you would do that in writing. FRBAR, you need to send an email or have the buyer sign a termination document prepared by an attorney. NABOR provides a form for terminating under the finance contingency. Other questions about financing? Yes, Iko, I will send a link for the webinar and I will send out my slides. I should have said that at the beginning. I apologize.
So Sam, on the NABOR for what you just spoke about, you're saying it's at the end. So let's say on Wednesday it ends, right? That's right. The 40 some odd or 45 days. Then the following day, when you have 24 hours, 48 hours, I mean.
No, you can terminate all the way up until closing.
All the way up until closing, okay.
Right, but remember, NABOR and FRBAR both require good faith and diligent effort. And if you get loan approval under NABOR, I have often argued on behalf of the seller that the buyer cannot just terminate and get their deposit back because they got loan approval. That hasn't been tested, and we've had to work it out in every case. But I'd be very careful if I got loan approval about trying to terminate under the NABOR contract. I would actually say the same thing about FRBAR, because FRBAR has a provision that says once loan approval is obtained, the buyer shall notify, they use the word shall notify the seller of loan approval. So if you get loan approval, I think you're going to be stuck going to closing or losing your deposit under both contracts, but I have not seen that case. That's just Sam Saad's theory. So it's a case-by-case basis. Okay. Let's talk about HOAs and condos for a minute. So under FRBAR, you have to use the correct addenda. You have to add the rider A for condos or rider B for HOAs. The language that the statutes require is not in the standard FRBAR contract. You must use the rider. When you sell a condo with a FRBAR contract, use the rider. I can't tell you how many contracts I get in where the rider's missing, and if you go back and add a bunch of detail so that you can have a proper closing. Under FRBAR, you get the approvals and right of first refusals have to be disclosed up front. And you disclose the association fees on the addendum. This is a big deal. A lot of people complain about the NABOR contract because we don't have a place in the contract to disclose the fees. NABOR provides a separate worksheet to disclose all of the fees. So for example, in Collier County, if you sell in Vanderbilt Golf and Country Club and you've got 8 different fees that have to be paid, the NABOR form is very accommodating to that, that type of situation. Under the FRBAR contract, special assessments are negotiated. You check the box. Under the NABOR contract, the seller pays all special assessments due before the effective date. And the default under the FRBAR contract is that the seller pays all special assessments due before closing. So the NABOR contract has a very complicated scheme for dealing with special assessments of associations. I see a couple of questions, and I'll get to them in 1 second. But NABOR says if a special assessment is due and it has a 3-part test, the seller pays it prior to the effective date. If a special assessment comes in after the effective date and it was a pending assessment, and no one really knows what pending means under the NABOR contract, but I would submit to you, if the board has discussed it at a meeting, if a vote has been taken to move forward, if it's come up at the members' annual meeting, it may be pending, and then the seller needs to give the buyer notice or pay up to 1% of the assessment, up to 1% of the purchase price towards the assessment. And the NABOR contract has 2 disclosures about assessments that make it the buyer's responsibility to investigate and understand the community association requirements. And the other thing is the statutory disclosures that are not in the FRBAR standard forms, but are in the addenda, are right in all the NABOR contracts. So you don't need a rider or an addenda under NABOR. Okay, a couple more questions I see about financing, so let me answer those. Bob is asking, what happens if loan is approved, but for a lower mortgage due to low appraisal under NABOR, can the buyer terminate and get their money back? Bob, absolutely. The reason that you write the amount of the loan on page 1 of both contracts is because if the buyer does not get approved for that amount of money, then the buyer can terminate. Now, this gets a little bit tricky where you've got a high down payment and a low mortgage amount. If the buyer gets approved for the loan amount stated in the contract, but the property for whatever reason doesn't fully appraise, there's an open question that's whether the buyer's got to close. And I would say the buyer probably has to close because they got the amount they applied for under the finance contingency. Okay, let's see what we've got here. Tammy is asking, I have issues with lenders providing conditional loan approval within the first few weeks of the contract. That's their only term for their lender. The appraisal's not in. Well, I would say that the appraisal doesn't come in under FRBAR, Tammy, then that's a reason for a buyer to terminate. Because it says that they have to get the appraisal done and get the application in. Okay, Batia is asking, is there an amendment form in Form Simplicity? I used an addendum form for changes. My broker doesn't have an amendment form. Batia, you must be talking about FRBAR. FRBAR does not provide a quote unquote amendment form. They use an addenda form for everything. Practically speaking, if you use an addenda form under FRBAR for an amendment after the contract is signed, all will be fine and don't worry about it. If you want to be technical, you should do an assignment once the contract is fully signed. Okay. Title insurance, of course, big one for me. Yes, someone's asked a question.
I have a question. So let's say you have a pending contract and the POA decides to then change transfer fees, which has just happened in a community, by the way, so everyone else can hear. In Bridgewater Bay, they just voted that our transfer fee would go from $200 to $2,750. So it's a huge jump. What if there's a contract that's already pending? Does the buyer then
the new amount would be properly prorated? The seller would pay it if they owe it and get their proration back, and the buyer would pick up the new assessment. And if your next question is, can the buyer terminate because they don't like the new assessment? I would say it depends on the loan. If the new assessment throws off their monthlies and their debt to income ratio doesn't no longer matches up and they get denied a loan, then maybe the buyer could terminate for that, but they probably cannot terminate.
So the buyer, I'm just asking if there was like an additional review period if that happened.
Not at all, no.
Okay.
No. Okay. Maria is asking about whether the buyer is required to find out about assessments if they come up during the time of the listing and the listing agent doesn't update the listing. Under the FRBAR contract, I would say that that's an open question, Maria, but under the NABOR contract, it's pretty clear that the buyer's duty to investigate the association. The buyer has the duty. So you've got to get that done before you go to contract. And if it changes during the contract, as Christina was just talking about, then you're going to have to work it out. And I will say this, having gone through Irma and Ian, the reason we are so successful around here with our contracts is because the realtors, the lawyers, the buyers, the sellers understand that it's not perfect and you have to work it out. You got to come to a reasonable solution for everybody. Otherwise, nobody wins but the lawyers when you go to court. So we try to avoid that at all costs. Okay, title insurance, my favorite topic as a person who writes title insurance. Under FRBAR, you check a box for who picks the title agent and pays for the owner's policy. Under NABOR, it's a default that the buyer picks the title agent regardless of who pays for the owner's policy. And there are not any options under NABOR. The seller pays in Lee and Charlotte County and the buyer pays in Collier County. NABOR's contract doesn't address the other counties in Florida just because it's more of a local form. FRBAR, of course, is more flexible. And don't forget the lien search follows the title insurance. So that's $104. It's picked up as an additional fee, whereas under NABOR, the buyer pays for the lien search in all cases. Time being of the essence in the FRBAR contract, one of the deadlines that nobody remembers is getting that title commitment delivered on time. The title commitment is due to the seller 5 or 15 days before closing under FRBAR, depending on the financing. Think about that. If you've got a 5 days before closing and then you get your title commitment and all of a sudden there's a title problem, that's a real mess. So NABOR in this regard, I think, does it a little bit better, where they say the title commitment is due to the seller 10 days after the effective date. So the seller has, the time during the contract to clear title. Not a big deal for the realtor so much as for me as the title agent and the attorney doing the closing, to make sure we get that title commitment done right away, get it to the seller and get title clear so that you can have a closing. Excuse me. Okay, inspections. Big differences under inspections. Oh, wait, we have a question, Bob. Bob's asked about transfer taxes under both contracts. Bob, the seller pays for the dock stamps under both contracts. But again, those are all negotiable fees. So you can move them around. You just have to write in additional language. So I see that a lot where sellers will pick the title agent, but then they want the buyer to cover the dock stamps. That's a fairly common thing. Okay, inspections. So FRBAR's inspections, they give you 3 inspections for general inspection, a WDO, which of course is wood destroying organisms, termites, beetles, other sorts of things, and permits. FRBAR has a rider for a mold inspection. NABOR provides for 6 inspections, including systems and equipment, which is of course your air conditioner, your washer, your dryer, your appliances, your systems and equipment that run the household, radon gas, lead-based paint, WDO, mold, and open permits. The way the inspections are conducted is very different. The contracts, you need to understand the inspection regime that you're going to be using very well, because you don't want to get in a situation where you miss an inspection or you misnotice somebody. So, and I do a class on both contracts and I go into detail on the inspection items, so I won't do that here. But just know that if you use the NABOR contract, you get 6 different inspections. Under FRBAR, you get 3. FRBAR's inspections, I guess I'm going to talk a little bit more about inspections in a minute, but the threshold amount for the seller to spend is the 1.5% of the purchase price. If the repair limit is exceeded, then you must give notices, and then either party can terminate under the various inspection provisions. Tammy, WDO does not cover bats, rodents, and bees. You have to add that in. And then under NABOR, remedial action is limited to the fair market value of the items in working condition. So you don't get new stuff, you get repairs. Then of course, NABOR has got the 15-day default for inspections, 5 days for the buyer to review their reports, 10 days for the seller to respond to those reports. And if the seller counters the inspection request of the buyer, then the buyer gets 5 days to terminate the contract. And there are forms provided under NABOR to guide you through the inspection process. I will say this, FRBAR's got a lot of good forms, but NABOR's got 80 forms to get you through the closing process. So as a person who chairs the committee, I kind of like those forms because they really help the realtor. They're good tools. A little more on inspections. FRBAR has differences as to what has to be repaired. Torn screens, fog windows, missing roof tiles are defective. They are items that you would repair under FRBAR. They're cosmetic under NABOR. FRBAR provides a procedure for dealing with inspection items, and I call it the dueling experts. The buyer picks their inspector, the seller counters with their inspector. If they don't agree, then you get a third inspector picked by the inspectors, who is the definitive response for whether you have a defective item or not. And then open permits, you can actually get up to a 10-day extension under FRBAR to deal with final inspections under permits. NABOR has a totally different process for permits. There's no real procedure for dealing with inspection reports under NABOR. You just deliver it and then you hash it out during that 10-day period. Or an open permits, you actually have until 5 days until closing to find them, because Collier County, where most NABOR contracts are used, has been very slow to get information out about open permits, but it does not extend the closing. And then Kayla, you want to know about the 15-5-10-5 one more time? Sure. So under NABOR's contract, you've got a process you go through where the buyer's got 15 days to do inspections, then 5 days to review the reports of the inspectors and get them to the seller. The seller then has 10 days to, we'll call it, negotiate the inspections, review the inspections, determine if they want to complete the inspections. And if the seller counters the buyer's correct election or rejects the election because the seller is not obligated under the NABOR contract to make repairs, then the buyer would have 5 days to terminate.
And that's
Bati is asking, do you think it's okay to close out it's okay to close prior to a permit being closed out? Yes, Batya, you can close with open permits. Permits do not affect title. I typically would have the parties do some type of what do you call escrow to cover the open permits. Kayla, did you have a question?
yeah, so that's for as is and the standard on the 15-5-10-5.
Nope.
Just-
As is a free look for both contracts during the inspection period. So
Yep.
if you've got a FRBAR or a NABOR as is contract, the buyer can terminate for any reason or no reason during the inspection period. After that, they're locked in.
Okay, thank you.
Okay. A little bit more, I mean, because inspections are such a big deal. You know, the under FRBAR, the buyer notifies the seller within the inspection period. As I was talking about this with the 5 days, the buyer conducts searches, and they have, as long as the buyer conducts a search for permits within 5 days, let's make a request to the county for open permits, then they can collect or they can get their permits remediated. Remember that closing is not extended for open permits. Now, FRBAR open permits, much more complicated. There's a much more complicated regime. The seller has to provide documentation that they have in their possession. They have 10 days to get estimates and get those to the buyer. And the seller has until 5 days before closing to get the permits closed. And then there can actually be a 10-day extension for inspections. And there is a provision that if the costs exceed the permit limit, the seller fixes all the permits or the buyer can get a credit. So you gotta be very careful with permits. They get in people's way all the time, but you can close with open permits. Okay, Chet, you're asking, Chet, I have a whole different class where I go through the NABOR standard and as is contracts. That's my NABOR contracts class. So that's on my YouTube channel. I'll take a moment to plug my YouTube channel. My 13, 14-year-old love the fact their dad is a YouTuber. But if you want to get into details on that, Chet, go to my YouTube channel. I will give that class again soon as well. Okay. Let's talk about force majeure and risk of loss. Oh, we have a question on permits. Can you do a class on permits? I will try to do a class on permits for you. That's a good idea. Okay, force majeure, risk of loss. So very different formats. FRBAR has a specific force majeure clause, whereas NABOR does not. Under the FRBAR contract, force majeure is a defined term, and you have to use reasonable diligence and be unable to overcome the force majeure. And if that is the case, then you close 7 days after the force majeure event passes. That doesn't mean it's 7 days after the hurricane passes. It's more like 7 days after the power comes back on. And you can extend for a maximum of 30 days past the closing date. And I'll say the new FRBAR contract specifically includes pandemics, which of course we just went through. And the seller has a risk of loss limited to 1.5% of the purchase price under FRBAR. NABOR, again, very different, no force majeure clause. Seller bears the risk of a casualty, which is a defined term, that's the hurricane. If the buyer can delay closing after a casualty if they cannot get insurance at a reasonable rate. So if the insurance, if we're in the box and you can't get insurance, then the buyer can delay closing. They close 5 days after coverage becomes available, up to 30 days after the casualty date, not the closing date. So it's a different extension period. You measure from a different place. Be very careful about this because it can screw it up if you think you got 30 days past closing. No, you got 30 days past the date the hurricane passes. And if the property is uninsurable under NABOR, the buyer can terminate after the casualty. Okay. Christina is asking, how has reasonable definition now changed? Oh, that's a great question, Christina. Thank you for asking that question. Forgot to mention it. Reasonable means using technology, DocuSign, remote online notaries. The technology is such that we have really not had a problem getting things closed throughout the pandemic or after hurricanes. It's just that if there is an unavailability of services to close, like the power's out at my office and I can't, or the internet is out and I can't get the DocuSign out, then we would delay closing. But if I can get you a DocuSign and you're a buyer and you just don't want to close because you're scared of the hurricane now, you're going to lose your deposit. So reasonable diligence to overcome includes the use of the technology available to us to get past the pandemics and the hurricanes. Okay, a few more slides. Time of the essence. Major difference and major problem for people who can't meet deadlines. Under FRBAR, time is of the essence for each and every deadline in the contract. You cannot miss a deposit deadline. You can't miss a title commitment delivery deadline. And you certainly can't miss the closing date. NABOR, time is of the essence only for the closing. But of course, lawyers, there is a case, Nechachuchi Corp versus Pickett, where it says the deposit is such an important part of the contract that you should not miss that deadline. So the way you deal with missing a deadline under NABOR is you put the party in breach and you give them a reasonable opportunity to cure. What does that mean? That means that the lawyer sends the breaching party a letter, and it says, if it's the deposit, for example, buyer, you missed the deposit deadline. You have 1 business day to complete your deposit, or we're going to terminate the contract and keep your first deposit if it's the second deposit. So you got to notice the default and give an opportunity to cure under NABOR. Under FRBAR, if you miss a deadline, time is of the essence, the contract terminates. And this is another big difference, talking about default and dispute resolution. Under FRBAR, all deposits go to the seller if the buyer defaults. Whereas under NABOR, the seller's only remedy actually, is deposits made. So if the seller's got marketable title, they're selling under both forms. If the seller does not have marketable title at closing, there's an extension. But if the buyer defaults either for financing or they don't want to close, they have all types of other problems, and the buyer doesn't want to close, they're going to lose all of their deposits under FRBAR, whether they made them or not. And under NABOR, it's only deposits made. The other thing is FRBAR provides the dispute resolution process. You have a 10 days of dueling letters between the lawyers to determine who is at fault, and you fight about it. If you don't settle, then you go to mediation, and then the prevailing party gets their attorney's fees paid if you go to court. Under NABOR, there is no real dispute resolution process. You just sue each other. Great question, Colleen. Who determines marketable title? Colleen, I have a 1,000-page book written in the 1920s that tries to define marketable title, and it can't do it. Marketable title is simply a title that can be resold. It's whatever two lawyers come up with as agreeing to the title being marketable. Typically 99.9% of the time, if the title is insurable under the Florida title standards, the title is marketable. There's a 300-page book out there called the Florida Title Standards that I have a copy of if you want to see it. But it basically defines when a title can be resold without having to resort to litigation.
And it doesn't affect title insurance.
Again, Colleen, say that again.
And it doesn't affect title insurance.
Well, if the title is insurable, it's marketable. It's when
Okay.
the title is uninsurable but may still be marketable that you have a problem. If you can get title insurance on the property, it's marketable, and the seller's got to sell. Okay, Maria is asking, if it does go to the 10-day dispute, can you still show the property to other potential customers? Maria, there is no prohibition on you continuing to market the property to potential buyers all the way up to the closing. I know a lot of realtors question that, but there is nothing in either contract that says you shall not show this property to a potential buyer and take backup offers. So you can do that all the way up to the closing. You just have to make sure that your seller does not obligate themselves to sell the property to two people, because now your seller's got a problem. So just be cautious how you handle those, but you can absolutely, you do have to switch it to pending, Joe, that's correct. But it will show pending in the MLS, but there are plenty of ways to market a property that don't include the MLS. Of course, you have your email and text lists that you can send, your circle of influence that you can call. That is perfectly allowed under Florida law. It's not, unless it's in the contract, it's allowed. Okay, I've got one more big topic to cover that's brand new, but do I have any questions at this point about what I've covered so far?
Sam, are you gonna talk about insurance next?
Insurance? Which kind of insurance?
Well,
Homeowners insurance?
yeah, on the previous slide, you talk about the force majeure, right? In case of a hurricane. I
Right.
noticed that a lot of insurance companies stop on a certain moment to issue homeowners insurance.
Right.
What do we do in that case if we have a closing and the policy is not issued yet?
Yeah, that would be an event that under both contracts, you would pause the contract and wait for the hurricane to pass so the party can get insurance. Both contracts allow for that. That's
Okay,
a great
thanks.
question. Great
Thanks.
question. Yeah, if the property is uninsurable due to the passing hurricane, both contracts allow a pause in performance.
Okay,
So you would
thanks.
just wait for the hurricane to pass.
Great, thanks.
Okay. Next topic, new slide, if you've seen this presentation before, but we have a new law in Florida. New law involves foreign countries of concern, foreign buyers. If you are from one of the seven, we'll call it the seven deadly sins, the seven deadly countries, China, Russia, Iran, Korea, North Korea, Cuba, or Venezuela, or Syria, it is a crime to knowingly buy or sell property in violation of the new law. That is section 692-201 to 205. Basically, what this law attempts to do is protect American interest, Florida interest from foreign owners near military installations, large agricultural parcels, more than military installations is critical infrastructure, I believe is the word they use in the statute. And that includes water. This is Florida. How much water infrastructure, pumping stations, and everything else do we have? There is a map floating around the internet. I do not endorse it, but it does exist. If you want to see where some of the critical infrastructure is, it basically covers everything but a hole this big in the middle of Lake Okeechobee. So the law is very broad. It does contain criminal provisions. And the way you deal with it is the buyer must sign an affidavit saying they comply with the act. And this contract, this box, by the way, that you're looking at on your screen right now, this is in both the FRBAR and the NABOR contract. It's the exact same NABOR copied FRBAR with permission. And at the time of purchase, the buyer must provide a signed affidavit complying with the requirements of the act. And they are advised to seek legal counsel regarding their obligations and liabilities. I will tell you, this law is totally screwed up. It's not being promulgated. The rules under the law, there are 3 separate state agencies that have to provide rules under the act: the Secretary of State, the Consumer Affairs, and FREC, the Florida Real Estate Commission. The affidavit that you see talked about in this section right here, that actually has to be provided by FREC. FREC has not done that yet, even though this law is effective as of July 1st. So right now, today, your buyers have to sign an affidavit. I will provide an affidavit that complies with the law. So if you have that question, just give me a call or a text and we'll get you the affidavit. But this foreign interest law is going to be a problem. And Christina, you are correct. If you are a Chinese, Iranian, Korean, Cuban, Venezuelan, or Syrian, or anybody else that meets the criteria under the act, and you own property near critical infrastructure, depending on which of the 3 sections you fall under, you may have to sell within 3 years.
Sam, how does this affect fair housing, treating everybody fairly?
This is a major fair housing. There's a huge federal lawsuit. I'll show you. This is one of the briefs in the case. I've got them all. The Chinese citizens have sued the state of Florida and the governor and everybody else to try and get this law overturned under fair housing. And the court declined the temporary injunction. So the law is in effect and is being used right now.
Mhm.
And they said it's going to be a long time till they come up with a decision. So you've got to deal with it. And as realtors, the best way I think for you to deal with it is to not deal with it and let me deal with it, because you run into fair housing and you get sued, it's going to be a mess. Whereas I'm just a lawyer and I can tell the parties what the law says and they can make their own decisions.
Sam, I have a question.
Yes, Kat.
I'm Venezuelan and I deal with a lot of investors that comes from either Venezuela, Chile, Argentina, Brazil. And I want to be more careful, and I will definitely, and I'm so happy to have you as my number one when it comes to the title and as an attorney. And I will definitely contact you as soon as I have any of those cases in the future. But as a real estate agent, I want to know, what about that infrastructure? I want to learn more. So are you going to provide any training about specific?
I have a whole class on this. Yes.
Okay.
It's on my YouTube. It's not on my YouTube channel. I forgot to record it last time.
Okay.
I will put out another class and I will share the slides. If you send me an email, I'll give you the slides.
That would be awesome.
But basically, there are 3 sections to this act. It covers critical infrastructure, military installations, and agricultural land. And I know, Kat, I know, of course, we've spoken, and I know that you are Venezuelan, you deal with the Venezuelans. The interesting thing about Venezuela is it's not Venezuelans. It's the Venezuelan regime of Nicolas Maduro. No one knows what that means. If I'm a Venezuelan citizen, I live in Venezuela, but I am anti-Maduro. Maybe I'm in hiding from Maduro, even it's that crazy,
Right.
or I'm a rebel or whatever, whatever they've got going on down
Yes.
there. Am I part of the Venezuelan regime of Nicolas Maduro? I mean,
Yeah.
at least if you're Syrian and you live in Syria, or you're Chinese and you live in China, it's clear you are in fact a person of from a country of foreign concern. This language they used about Venezuela is very disconcerting because it is so odd the way it's written.
Right.
Um,
And it's something important, Sam. I have 29 years in this country, and I still know people that have, good financial situation in our country that because of the regime, they wanted to sell what they have and they want to come to US. They have actually legal visas. They have
well,
everything.
remember, if you live in the US and you are lawfully in the United States as a permanent resident, you can sign the affidavit and this don't apply to you. So you can be a Venezuelan if you are permanently in the United States under whatever reason. I don't think, and it's been an open question, but I don't think that refugees or what's that
People
called?
filing
Asylum
for
seekers
asylum.
count.
Uh-huh.
Asylum seekers don't count. But if you've got a green card, then you can sign the affidavit and this wouldn't apply to you.
For buyers. I mean,
For
like,
buyers. For buyers.
yeah. Okay,
We
great.
got a
Thank you,
bunch
Sam.
of questions on this, so let me just kind of go through them. The law affects only non-US citizens just based on race. Naomi, that's pretty much correct. It's non-US citizens, and it's not just based on race, but it's kind of based on country of origin, which is another protected class. That's why I think it should be struck down by the federal government, by the federal court, but we'll see what happens. Oh, good. Della says FREC has a webinar on this at 1 o'clock today, so get on. That's right. FREC's got the big hearing today on the new affidavit. So if you've got time, tune into that. Maria is asking if this is similar to one about that they placed in Canada. Maria, I'm not familiar with the Canadian law, so I'm not sure about that. Naomi, this only applies to purchases. So the buyer, it's a buyer only. So a tenant would not have to worry about this. Then Batia is asking, what about the title companies doing the closings? We realtors and title companies don't appear to have criminal liability under the act. Realtors are all the guidance that says that if, as a realtor, if you facilitate a transaction and the buyer is Iranian or Russian and they live in Russia or Iran, you would not be liable. The affidavit is going to come from FREC eventually, but we have one that's from our underwriter. So just be careful about that. Other questions that people have?
Sam, is that true? They talk about people who already bought before July 1st that they were supposed to register on a website or something.
That's right.
Like that?
There's supposed to be a registration. If you own property and you're one of these people, you have to register. There are exceptions. I should not say this is a blanket, but the exceptions are so small, they're almost swallowed by the rule. You can own up to I don't want to say a certain amount of acreage within so many miles away from critical infrastructure, then you can still own it. If you're like Chinese or something, there are special rules for the Chinese people, and then there are different rules for the other 6.
Okay.
So it's like I said, I have a whole slide deck on this. I'll send that to you, Kat, and anybody else that wants it.
Thank you.
Oh, wait, somebody just posted the webinar to the chat. So everybody take a look at the chat. This is very important in my opinion. You should try to go to this if you can. Grab that link.
Sam, there's an article.
And go to that.
There's
You
an
got the chat
article, Sam,
open.
and I'll try to find it to send. But there's somewhere, I think it's up in one of the northern states where there were thousands of acres that were purchased by a Swiss company. And it turns out the Swiss company was not a Swiss company. It was actually owned by the Republic of China.
Right. That's what triggered it up in, I think it was South Dakota near the missile range.
Right.
Or it was North Dakota near the missile range.
And it's such a large food supply.
There are now, I believe, 30 states that have these types of rules in place.
Correct, yeah.
And then someone's asking, have you done a contract comparison for FRBAR? I have a whole FRBAR class. Yes, that's on my YouTube channel, and I'll probably do that again in the future too. But you can go to my YouTube channel and see the FRBAR we talk about versus as is. And then Carol is asking, in a nutshell, this is my favorite question. If a seller says to you, what contract is better to use, FRBAR or NABOR, what would you say? Carol, I would refer them to my first slide and say, it depends on your buyer and your situation. Unfortunately, I never know which hammer or screwdriver to use until I look at the screw or the nail. So you gotta just analyze the situation and come up with the best solution. And my contact information is on the screen, so you can always call, text, email me, and I'm happy to walk through the situation with you and come up with your best solution. And with that, I'm going to say thank you, thank you, thank you. I will talk to you all soon. You should feel free to email me, text me, call me whenever you need. And
Thank you, Stein,
take care.
for your time. Thank you.
Bye-bye.